Newsfirst, Newsline.
Hello there and a very good evening to all our viewers watching Newsline live here on TV1. I'm Gehan from the Newsfirst team, joining you from our headquarters here in Colombo. Today we will be talking about anti-terror laws in Sri Lanka and how we can strike a perfect balance between those laws. Why are they draconian? Why are they considered harsh and whatnot? And to talk about this topic, we are joined by attorney at law, Dr. Gehan Gunatilleke, all the way from the United Kingdom today. Thank you very much, Dr. Gehan Gunatilleke, for joining me this evening.
My pleasure, Gehan.
Dr. Gunatilleke, before we go into detail about anti-terror laws and striking the perfect balance between these, let me give our viewers a bit of a briefing on what the Prevention of Terrorism Act is, because the Prevention of Terrorism Act has re-emerged and the use of it has re-emerged. So the Prevention of Terrorism Act was introduced in 1979 as an emergency measure and was passed in a single day's debate in Parliament. Ever since then, the Prevention of Terrorism Act has been part of the rule of law in Sri Lanka. So without further ado, I want to get into questioning and picking the brain of Dr. Gunatilleke on why it is considered draconian. So Dr. Gunatilleke, on the outset of things, can you tell me whether you believe that the Prevention of Terrorism Act requires amendments or whether it should be repealed and replaced with a new act altogether?
No, absolutely. It's one of the blackest marks on our statute books at the moment. It needs to be repealed. If it is to be replaced, it has to be replaced by a law that has a completely different sort of mindset. If a law can have a mindset, I think it really needs to be something that departs from the current framework of the PTA. If you look at the preamble, Jamal, of the PTA, it reveals exactly what the thinking is behind this law. It says that Sri Lanka continues to be endangered by elements or groups that advocate the use of force.
Okay.
Right. So now this is back in 1979. As you can imagine, the sort of groups that were in operation at the time.
At the time, yeah.
But then there's a crucial phrase here: the use of force to accomplish governmental change within Sri Lanka. So that is at the heart of the law, is to preserve governmental interests. So now if you think about terrorism, just a common sense definition of terrorism, you would understand that it needs to relate to the protection of civilians, right? Protection of civilians from indiscriminate violence and violence that is perpetrated for a particular cause. That's the sense that you would get when you talk about the term terrorism. But in Sri Lanka, the counterterrorism law, the premier counterterrorism law, which is the Prevention of Terrorism Act, is really not about protecting civilians. It's about protecting governmental interests. And then you begin to understand why it is actually applied in the way it's applied. It's not designed to actually protect civilians from the sorts of attacks like bomb attacks or hostage takings or hijacking of aircrafts. These are the sort of things that you might associate with terrorism.
Terrorism, yes.
PTA doesn't actually address those things. It addresses governmental change through force. Now, the moment you think about a law that is designed in those terms, anything that you might do that challenges the government could potentially be placed within the framework of terrorism. And that is what we are seeing here today, right? A law that was designed once upon a time to deal with a particular type of violence is now being repurposed to apply to all kinds of things. And that's why those who are involved in protests today are also being cast as terrorists. So there's a fundamental problem with this law, and it really has to go.
So, Dr. Gunatilleke, you spoke about this law being repurposed to serve the interests of the government, a sitting administration. The law, the Prevention of Terrorism Act, was used most recently to investigate Vasantha Mudalige, the convener of the Inter-University Students Federation, Hasantha Jeevantha Gunatilleke, and also Venerable Galwawa Siridhamma Thera, when they were detained for a period of 90 days starting from Monday. A couple of days later, the police media division issued a lengthy statement, and they also cited the UN Security Council Resolution 1566 of October 2004 as relevant in the use of the PTA to investigate them. Do you view this as sort of an indication given by the government to the international community that has condemned the use of the PTA in stopping dissenters?
No, I don't know. I don't really understand why that particular UN Security Council resolution was referred to in the first place, because that resolution in 2004 actually deals with threats to international peace and security. So I don't really know why the police might even try to make the argument that protesters in Sri Lanka were a threat to international peace and security, and cite a resolution that they clearly have no idea what the resolution is actually talking about. So I just wonder whether someone was trying to be clever there and include an international instrument that deals with the subject of combating terrorism and try to plug in a reference there without actually understanding what that resolution was all about. So I wouldn't give too much credence to that reference. But to answer your question, from a different point of view, I think it's really important to understand that there's a distinction between public security and state security, or what we sometimes call national security. And fundamentally, terrorism is about threats to civilians, right?
Yes.
Threats to civilians, indiscriminate attacks on civilians. So if we don't think of public security as the central objective of a counterterrorism law, and instead it's about preserving the state, we move from the concept of public security to the concept of national security or state security, which is a different purpose altogether. And I think the PTA in practice has really been about the latter objective, as I said before. So people who challenge the state are the ones being targeted. Now, there's a problem here, because if you think about actual violence against civilians, like the violence you saw in 1983 during the pogrom, or the anti-Muslim violence that you've seen since 2014 in various parts of the country.
Yeah.
You never actually see the PTA applied to those perpetrators. So in a way, our conception of counterterrorism in this country is both over-inclusive on the one hand, because it's including peaceful protests and anti-government action, which is legitimate and which might be protected under the Constitution. So it's over-inclusive, but it's also under-inclusive, because it doesn't include the actual violence that might be perpetrated against civilians for ideological causes. So that, I think, is a really deeply problematic sort of conception of counterterrorism in the country, and the PTA embodies that.
So, Dr. Gunatilleke, are you insinuating that competent authorities, those in power, have somewhat confused the two facts of public security and national security, or are they simply using this draconian law in their favor at a time where there is a revolt against their regime?
So that's a great question, Jama, because I think what is happening is that a law that is designed for a particular purpose is being repurposed, and then the state is actually in bad faith applying it to a context that doesn't really involve terrorism at all. But I don't think there is a conceptual confusion here. I think this has always been the problem with the PTA. The state gets to selectively apply it, and that's the problem with these laws, right? And it's a problem in the state itself. So if you look at some of the other laws that are a little better, like the ICCPR Act, you see the same problem.
Right.
These are model laws that are still applied in a bad faith manner. So I don't think sometimes the reform of the law is sufficient to deal with the problem of a state using laws in bad faith. You can have really bad laws like the PTA being used in bad faith, and you can have very good laws like the ICCPR Act also used in bad faith. So the bad faith of the state is the problem. I don't think there's confusion. I think this is just a case of utilizing whatever repressive tools one has at one's disposal to further one's interests. And the interest here is the suppression of dissent and the ensuring of a situation where people think twice before calling for another regime change.
So you spoke about the state using these laws in bad faith. Are there no safeguards for such a situation, Dr. Gunatilleke, even in the law?
Again,
to
great question.
prevent the state acting out in bad faith and using such laws in an unnecessary manner?
So obviously we can go to the Supreme Court and file fundamental rights applications. We can go to the High Court and file habeas corpus applications. We can go to the Court of Appeal with writ applications. There are various remedies that are available. But there's a fundamental problem with the PTA. And I think it's important to understand that as much as it is a repressive tool against suspects, which everyone is talking about, it's also an affront to our judiciary. It's an insult to our judiciary, because the judiciary actually has a time-tested, ancient, sacred role in protecting the liberty of suspects, liberty of persons who are taken into custody. That's the role of the judiciary. We train our judges to be able to perform that role. We trust our judges to be able to do that under ordinary law. Right? So if there's someone who's a murder suspect, you trust the judges to be able to evaluate the situation and make a determination as to whether the person is going to be released on bail or remanded.
But at the same time, his or her human rights are protected.
Of course, because I mean, there are times in which the fundamental rights of a person will be violated, but then there are remedies. But what I'm saying is there's a fundamental problem with the PTA because it takes away the power and jurisdiction of judges to make those calls and places that power in the hands of executive authorities. And if you take all the procedural problems with the PTA, you'll see one by one, what it actually does is take away the power of the judiciary, judges. So, for example, if you take away if you look at the situation with respect to producing a suspect before a judge within a particular period of time, the PTA dispenses with that. What is that telling you? That the state doesn't trust a judge to be able to evaluate a suspect.
Newsfirst, Newsline.
Hello there and welcome back to Newsline Live here on TV1. We are in conversation with Attorney at Law Dr. Gehan Gunatilleke on striking the perfect balance between anti-terror laws and how they can be reformed to ensure the rights of those who are accused and investigated through such laws are also ensured at the same time. Dr. Gunatilleke, just before we crossed over for our headlines, you were talking about the state assuming that the judiciary is incapable of upholding the liberties of those accused. Do you want to carry on from there, Dr. Gunatilleke?
Yeah, I mean, this is a really important question, Jamal, and I think your whole framing is about striking a balance, right? And the question is, okay, so let's say we need to strike a balance between national security interests or public security interests better than national security, but and on the other hand, the interest of the suspect, right? The fundamental rights of the suspect, the liberty of the suspect. You need to balance these two. Now, who is best placed to strike that balance? That is a fundamental question. And I think it's fair to say that judges are best placed because judges are trained to hear evidence, to see both sides of a particular issue and make a determination. Police officers, Ministry of Defense officials, these are not people that are trained to make those kinds of calls, right? So I would say if a balance is to be struck, we have to place that trust in judges to make those important calls. And what the PTA does fundamentally is take away the jurisdiction of judges. So we started by asking the question, why is the state not trusting judges to actually be able to evaluate the well-being of a suspect? What's the logic there? That you don't want to produce a suspect before a magistrate? What is the possible logic of not trusting a judge to be able to view a suspect and ascertain the well-being of a suspect? If you intend to treat the suspect with dignity, surely a judge can evaluate that. So that's number one. Number two, I was just, when we got interrupted, I was just talking about confessions. Normally, under normal law, a suspect can make a confession to a magistrate, and that confession is admissible. But you don't allow a suspect to make a confession to a police officer for obvious reasons. Now, why does the PTA displace that rule, that principle, and allow a suspect to make a confession to a police officer not below the rank of ASP, right? So again, are you saying that a judge is not a trustworthy, institutional actor that can receive a confession, and instead you want to transfer that important authority to a police officer? Another classic example would be the determination of whether or not a person should be granted bail. Now, a judge is trained to do that. That's what a judge is trained to do, to evaluate the circumstances and determine whether a person should be released on bail or remanded.
Yes.
And the Bail Act, Jamal, let me tell you, is very, very broad in terms of the grounds on which bail can be refused. Now, if, for example, a suspect there's a risk of the suspect absconding or perhaps interfering with a witness, or even there's a chance that there will be a public sort of outcry against the suspect being released because of the nature of the offense. Even that is included in the Bail Act as a grounds for refusing bail. All the police needs to do is to present the relevant evidence to a judge, and the judge can evaluate and see whether this person should be either released or remanded. That's the job of a judge. Now, in the PTA, you remove the application of the Bail Act altogether, and then you remove any kind of discretion to decide whether or not a person is a threat or not. And that decision is normally with a judge. That's removed completely. And then instead of allowing a judge to make that call, you can secure a detention order. And how is a detention order secured? You go to the Ministry of Defense, you ask the minister to rubber stamp a detention order. You say that this person is a terrorist, suspect, and that is just issued. There is no evaluation or careful thinking there. None of the balancing that takes place in a judicial hearing takes place there, because the suspect can't make a case for not having that detention order issued. Right? You don't have a right to be heard there. The minister will decide, and often it's some defense ministry official that will decide, and the minister will rubber stamp it. So essentially, what are you saying? You're saying that we don't trust our judges to be able to make those calls, to decide whether a suspect is a threat to society or not, and grant bail or remand the person. You're taking away that power. That is the problem with the PTA. So apart from how repressive it is a total affront to the independence of the judiciary in Sri Lanka. And whatever law that replaces the PTA cannot be a continuation of that kind of affront to one of our state institutions, the third pillar of government, which is the judiciary.
Understood. Carrying on with our conversation, Dr. Gunatilleke, I want to ask you this question as well, because there have been calls for the PTA to either be repealed, and governments have taken initial steps to amend the PTA as well, and then there was a proposal saying that a National Security Act will be brought that will replace the PTA as well in recent weeks. However, I want to ask you this particular question now. If a law is robust enough to mete out punishments, how do you ensure that this law is not weakened too much so that wrongdoers get away with minimum punishments for their wrongdoings, but at the same time, these laws are not too harsh that it takes the form of a draconian law or a draconian act? How do you strike that balance once more?
Yeah, so I don't think a particular law is ever going to be instrumental in protecting civilians from terrorism. I don't think we can look to laws to deliver that kind of objective. Laws are there, to deal with particular circumstances, particular offences, and we hope that it has some kind of deterrent effect. But if you think about terrorism and you look at all the studies on terrorism, the law that is applicable to terrorism is never a deterrent, because the people who engage in terrorism have objectives that are, so fundamentally opposed to, the rule of law and to democracy and to all the things that we hold dear in a law-abiding society, all of that goes out of the window when you engage in terrorism, right? So how do you expect law to deliver this objective of protecting civilians from terrorism? I think that's a misunderstanding of what law is supposed to achieve. There may be some deterrent effect if the punishment is harsh and all of that. But I don't think the PTA has ever been an instrument that has delivered for us, protection from terrorism. Instead, what you have is, better law enforcement, better strategy in terms of how to deal with the root causes of terrorism. There are all kinds of other things that we can discuss, but it's not the PTA that delivers that. What the PTA gives is an opportunity for law enforcement to cut corners, to do things in a way that is not rigorous. So where you would need to gather evidence and build a case against a suspect, which is the ordinary situation, under the PTA, you can just extract a confession. So if that confession states that the suspect has committed the offense, that in itself is sufficient to secure a conviction. So that really is what the PTA is about. And right now, when we think of the PTA's application to suspects involved in the protest movement, really what objective is being pursued is very simple. They don't want judges to give bail to these suspects because they think that is inconvenient, or they don't want the suspects to be granted bail. And what does that mean? That judges are evaluating the situation and thinking that these suspects are not threats to society, they're not flight risks, they're not likely to commit more offenses, and they're granting bail, right? Yes. But the police don't want to give judges that opportunity, so they're getting detention orders. So they're, in bad faith, fitting this in clumsily into the frame of counterterrorism or to the Prevention of Terrorism Act in order to circumvent the jurisdiction of judges. So really, at the end of the day, I really don't think that these laws are meeting the objectives that they are claiming to meet. Instead, they're just giving state officials the opportunity to circumvent the ordinary course of justice. And that's deeply problematic.
Right. Unfortunately, we are nearing the end of the show, but I must ask this from you, Dr. Gunatilleke. Let's talk about the international perspective. When the detention orders were signed earlier this week, and also the PTA was used to investigate suspects or those who were arrested, many foreign ambassadors from many missions in the country, they came out, and this drew large condemnation from the international community as well as many international organizations. Now, we know that the UN Human Rights Council sessions are set to get underway in a couple of weeks, and the UNHRC High Commissioner Michelle Bachelet is to provide a submission on Sri Lanka during the council meetings. How do you think, Dr. Gunatilleke, this particular development will change the submission of the UNHRC's High Commissioner? Will it be more rigorous? Will it be harsh? What sort of repercussions will this have? Because essentially Sri Lanka is at the mercy of the international community right now. We want all the support we can get to come out to show over this economic crisis. How do you view this in terms of engaging with the international community, but we keep on using draconian laws such as this in stark violation of accepted principles in terms of human rights?
Yeah, great point, Jamal, and I think you're absolutely right to point out that there has been a almost unanimous condemnation amongst the international community when it comes to the application of the PTA, the present circumstances, right? I think the PTA has been applied across the board over the years in a draconian and highly selective, abusive manner. And the international community has been fairly consistent in condemning it. I think there have been times in which, particularly during the global war on terror, the international community has been less than unanimous on this subject. But right now, I think you're absolutely right. Everyone is very clearly condemning this. No one is buying into the narrative that protesters are terrorists. No one is buying.
Right.
I don't think it's something that people in Sri Lanka are buying, and I don't think people overseas are buying. And you're once again right to point out that Sri Lanka is at a juncture where it needs all the friends it can possibly get out of this crisis. And the timing couldn't have been worse. It needs GSP Plus, which is a EU facility that has been granted that is connected to human rights treaty compliance. It needs to engage the Human Rights Council constructively. And remember, the issues before the Human Rights Council are not just issues that are pertinent to the present. It's a lot about accountability and reconciliation, right, for violations that took place in the past. So why on earth would you add to that the gamut of issues that are already before the Human Rights Council by adding new issues to it in the present? So it really doesn't bode well for Sri Lanka when you have these additional issues where the PTA that was supposed to be not applied outside the context of terrorism is now being applied even against protesters. You're bound to get a lot of negative publicity and a lot of backlash in the coming months. And I don't think Sri Lanka can afford to do that.
Right.
I think it's much more sensible to apply the law in a good faith manner.
Right. Thank you very much, Attorney at Law Dr. Gehan Gunatilleke, for joining us, albeit from a completely different region. Thank you very much for taking the time of your day to apprise our viewers on what these anti-terror laws are, how they can be amended or repealed and whatnot, and how you can ensure the human rights, which is essential for Sri Lanka, especially at this juncture. Unfortunately, that is all the time we have for Newsline Live tonight. We have to make way for the primetime news. I'm Jamal Ratnayaka for the Newsfirst team. Take care and good night.